All rise. The Court of Appeals Division 1 is now in session.
Thank you. Please be seated. All right. Good morning, Council. We are here for oral argument in CV22-0022, Reading versus Southeast Valley Regional Association of Realtors. As you may know, we record and live stream these proceedings, so when you stand to argue, please announce your name and the name of your client. You have a maximum of 20 minutes per side. You are not obligated to run that whole clock out, but you're welcome to do so if you'd like. You also are entitled to reserve some time for rebuttal, but that is on you to do, and you can keep track of that on the podium. Please do keep in mind that we have read the briefs, we have reviewed the record, we have also conferenced the case, and with that, please proceed when ready.
Your Honors, good morning. May it please the Court. My name is Darlene Twist, and along with Christopher Combs, we represent the appellants, Charles and Jacqueline Redding. At this time, I'd like to reserve 8 minutes for rebuttal. Your Honors, this is a case involving the wrongful discipline of two hardworking real estate agents who were denied their due process rights. There are several issues on appeal as cited through our brief, and I'd like to go through them in order. First,
Counsel, if I could throw you off a little bit, but the last part of the court's minute entry, which seems dispositive, or like you'd explain why it's not dispositive of, at least of the rulings she made, was on failure to exhaust administrative remedies. I think that I'd like to know your thoughts on that. I know that doesn't come until later in your brief, but is it your position? What is your position exactly as to why the court erred on that? And specifically, isn't it true that your client did not take advantage of a proffered opportunity to have the appeal in front of a 5-member board? So I know that's a lot, but if you can, I'm trying to steer you in that direction.
okay, if I could answer them actually in reverse, it might be a little bit easier. With respect to not having that appeal, there was no joint report that was filed by the parties. The Reddings would not be able to do this alone. It's up to Sevrar to set the hearing, and they in fact had asked to have an appeal hearing when there was the issue with the 4-panel. We didn't get a response. We filed the lawsuit, and then after the lawsuit was filed, we heard that, yes, you are actually entitled to a 5-panel review. That has never happened. The only thing my clients...
They sent you a form saying, here's the panel members, tell us if you have any objections, right?
Yes.
You're not disputing that they offered you the 5-member appeal opportunity after you filed litigation?
No, not at all. It's just that Sevrar never actually scheduled the hearing. So we never knew the date, the time, place, location of anything that was happening. The only thing the Reddings received was a list of the potential panel members for that 5-panel appellate.
And when the trial court became aware of it, she said, would you like me to stay the proceedings? Let me know if you, the Reddings, would like to stay the proceedings, and you said no.
They didn't say no. My interpretation of what happened was they were given a deadline, I believe it was sometime in August, to basically produce a joint report where they would agree, both sides, to go to this appeal hearing, and that just never happened.
But is it true, okay, were you seeking an order from the court that to have the court order a new hearing? Under a new appeal hearing, not the grievance committee, a new appeal hearing?
Well, I don't know that the court necessarily needed to do that. It was up to Sevrar.
Well, I'm just wondering
to
if you requested that. Did you request that in your complaint or in your motion, in your motions? What relief exactly were you seeking?
We were seeking judicial relief because we believe that we did have a final.
Well, I understand that.
Relief for what?
Yeah, we've all read your complaint. We have a hard time figuring out what you were seeking. So help us with that.
Okay, so we want the discipline to be vacated. My clients have a perfectly clean record.
Vacated usually means, like, when we vacate a lower court decision, we vacate the decision and send it back to the lower court to do it right. Is that, because that was my initial inclination, and we've had a debate amongst us about what it was. To me, it looks like you asked for declaratory relief that it wasn't done properly. breach of contract because they didn't do it properly, some damages for the fines that were imposed to be returned to you, which implied to me, at least, and there's some language in there that says that you're asking for, in your first claim for relief, a judicial determination is necessary and appropriate, I'm reading from paragraph 71, at this time in order that each of the parties may ascertain their respective rights and duties and may conduct themselves accordingly now and in the future, which sounds to me like you want to go back and have the hearing done correctly. Am I missing that?
I'm not sure that, given all of the facts, that that's even possible in looking back.
What authority would a court have to tell Sevrar, you messed up and did it wrong, and now you can never discipline these people? Is there any authority for that? Do you guys cite in your complaint any authority for that proposition?
No, but there was a final decision that the court even found in July of 2020 that said that that last appeal decision was a final decision, and that's what we appealed to the court from.
Right.
I think the court said at the time you filed the complaint, that was the final decision.
Yes, but Sevrar never ended up scheduling that 5-panel appeal hearing, which would have been the appropriate next route. But at this point in time, the main relief my clients are seeking is that the discipline no longer apply to them. Because if we go back and look at the entire record, there really was no violation of an ethical duty that
So
they...
you're asking us then to say that Sevrar cannot discipline you because they presented insufficient evidence at the first hearing?
Correct.
So we have to enter like what would be the equivalent of a judgment of acquittal on your behalf if this was a criminal proceeding?
Essentially, yes. We truly believe that the discipline that has been imposed against our clients has to be presented. They have to disclose it every time they apply for a new job, anytime they belong to a new realtor association. It follows them wherever they go, despite the fact that combined they have 50 years total service to the Arizona community that's completely unblemished.
You're saying that, so your position is, so I understand you're saying regardless of what may or may not have happened in the appeal hearing, the facts as alleged or the evidence presented as a matter of law was insufficient to meet the grounds for discipline. Is that correct?
Correct, Your Honor. Basically, their standard...
Didn't the trial court find exactly the opposite?
Yes, but there are reasons throughout our brief that we believe...
If we wanted to, could we affirm the trial court on, let's say we disagree with the trial court on the exhaustion issue.
Mm-hmm.
Could we affirm the trial court's ruling that all your due process rights and the evidence was sufficient?
I completely disagree, no.
Okay. But could we affirm it if it was correct on that basis?
If it was correct, and I completely disagree that it was for all the reasons that I'm going to go through, then yes. However, there was no due process here. I mean, the fact that the original complainant wasn't even present to be able to be cross-examined, and the fact that a grievance committee member who had only read the front of the complaint is supposed to be cross-examined by someone is just hard to believe. I don't understand how they could possibly understand what was in that complaint with more detail from the person who wrote it and then withdrew it. In addition to that, the only witness that Sevrar called was Will Wright, and the only thing he could testify to were the hearsay violations in the slander violations in Article 15. In addition, the only other people who called witnesses were my clients, and then the seller, who herself testified that she knew exactly what she was doing, and she understood the post-possession issues, she understood the simultaneous closing. She even called the Chandler police 4 days before the close of escrow to find out what would happen to her if she did stay behind in that house. She knew, she was there, she was live, she was under oath, and yet the burden on Sevrar was clear, convincing, and strong evidence. And the only person who had clear, convincing, and strong evidence was the seller, and she was supposed to be the person who was harmed.
A little bit about the burden. So the burden, this was the burden on Sevrar at the ethics hearing, is that correct?
Yes, Your Honor.
And so then there's the appeal, and let's set aside the weirdness of an appeal that went away. At the Superior Court, wouldn't the Superior Court have been required to defer to the administrative process findings, or was there, what are you arguing was the burden at the summary judgment stage in the Superior Court on these merits grounds?
So at the summary judgment stage, we were saying that there was no proper due process. So all of the findings of the appeals hearing as well as the original ethics hearing were wrong.
Do you have any authority for the proposition that if the trial court, not us, but if the trial court had found a due process violation in the way the hearings were conducted, that the remedy is anything other than vacating it and sending it back for Severar to do it again?
Well, I think the court would have the final word as to certain findings of fact of what happened at the lower level, because the trial court attempted to do that.
I'm saying, trial court says, boy, they should have, your cross-examination rights were denied, and the evidence was insufficient, and they didn't meet their burden, or whatever. Every other case I'm aware of with respect to administrative law or even criminal law, when the trial court's hearing is flawed, you send it back to do it again and do it right. Isn't that what, I read your complaint as that's what you were asking for, but I don't know now what you did, what you asked for.
Well, so at the end of the day, yes, provided that Severar is going to abide by its own rules, which it hasn't done up until this point. I mean, I'm sure our clients would like there to be an order from the court saying, if you do this, you need to do it right. You need to make sure there are 5 people, not 4 people at that next hearing. And if that's the case, then you need to end that hearing and start a new one to make sure that you have all of the proper procedures in place. In fact, my clients weren't even aware of what the exact charges were against them in order to be able to prepare any type of defense. It just happened to be lucky, if you will, in that particular situation that Ms. Walgren happened to be there that day. And she was only there because she had filed an ethics complaint against Ashley Fernandez, who never showed up either.
So what is let's say we agree with you that the trial court erred on the exhaustion of administrative remedies doctrine, that, there's at least some argument to be made that that's a pre-litigation standard, and that what happens post-litigation, whether you characterize it as kind of a settlement attempt or whatever, shouldn't be invoked to dismiss the lawsuit. Wouldn't we send it back to the trial court to tell them now decide the merits issues and or the administrative issues, and the court could again offer that stay, and if Severar scheduled it, wouldn't you guys have to just go do your hearing at that point?
I guess we'd be bound to do that, Your Honor. However, I am hoping that the court recognizes that the failure to provide due process is a serious concern of this private organization, and private organizations, when they have rules, are required to follow them.
And I guess what Judge Morse, what we keep trying to get at is, what is it that you want? Just a statement from the court saying due process is important?
I'd like the court to reverse some of the findings of the lower court, which said that Chuck Redding was responsible for slander, which he wasn't, because he was never even found for that violation.
We're crossing the procedural and the merits, and I think that's the problem.
Okay.
The due process argument is we didn't get the process to which we were entitled. It was a 4-member, not a 5-member. We didn't get notice of that. That's not the same thing as he didn't do it or should not have been found culpable. So we're really kind of circling around and around, meshing these two arguments. If the court is finding that there was a due process violation, I think Judge Morse's point is there some other remedy that you were asking for other than for the court to send this back to Severar for a proceeding that comported with due process? Is that all you were asking for the Superior Court to do?
Well, so I'm looking at our complaint. Basically, in paragraph 68 of the complaint, we're saying that the court has the power to declare and adjudicate the rights in the legal relationships in the action, and we wanted a judicial determination as to that effect. So
this is all about claims that there were procedural violations that were not met. Satisfied.
Yes. So I think at this point in time, if the Lower court were willing to consider the arguments and decide whether there was truly a violation that they should be sanctioned for by SEVRAR. That would be the best scenario. If not, we would go back and have the proper appellate hearing, considering everything all over again and deciding whether the discipline should be vacated.
So let me ask you the same question that the trial court, I think, asked, but maybe didn't ask clearly, and I'll try and ask more clearly. Should we stay our proceedings and allow you guys to pursue a proper appeal now? Are you willing to pursue the appeal in accordance with the procedures required by the SEVRAR contract or guidelines?
We are willing if all of the procedures are in place and our clients have an opportunity to present a defense and actually be heard and know what they're being charged with, so that they have the right to do that and not have
So
someone.
there are a lot of qualifications there. But they all go back to the same thing, which was subsumed in Judge Morse's question. If SEVRAR is holding open an appeal hearing consistent with their rule book, let's just make that cover all of those due process things. If SEVRAR is holding up, you are saying that is the remedy that your clients would like, is to have their day in that hearing consistent with that rule book.
And if you lose the hearing, you could then go back to trial court and pursue whatever claims you think are appropriate then. So would that be a good way we could resolve this case?
Yes, Your Honor. My one concern, though, which has been the concern throughout the settlement discussions and the mandatory court mediation is, and we included this in our brief, is that SEVRAR now says that they can't vacate that discipline, because if they did, they would lose their charter with the NAR. And for us, that is the biggest risk to my clients, is the fact that they are branded with being disciplined for something that they really didn't do. And there was strong, convincing, clear evidence presented.
So just to
Go ahead.
really, just to pin that down a little bit, you're saying that although you'd be willing to go through the hearing, there's no point to it because the remedy, the ultimate merits-based remedy that you seek is no longer available?
That
Because
is,
SEVRAR won't give you the appeal hearing.
that is what I understand.
That's not what I was asking.
Oh,
I
no.
was saying, I understood you to say SEVRAR says it cannot vacate not that it can't hold the hearing, but that it cannot vacate the discipline.
Correct. If the discipline can't go away, then there's no point in having that appeal hearing anyway, because I think we'd be right back here trying to.
Well, so then what's the purpose of all this litigation? I don't understand. So you're telling me that a court order, they would not vacate the discipline even if a court ordered them to vacate the discipline?
I would hope the court would order them to vacate the discipline,
But you're
but
saying that by their own standards, their own appeal, what if their own appeals board said, you know what? You're correct. The Reddings, we rule in favor of the Reddings. That's not sufficient? I guess we're going to ask your opposing counsel these questions, but go ahead.
Sure. I mean, the main point of this whole litigation is to vacate the discipline so that my clients don't have to disclose it every time they join an organization or take a job with a different brokerage firm. And that is their greatest concern. It's not about whether they had 6 hours of continuing education each or a $500 fine. It all comes down to whether they're branded with this discipline
Didn't
or
they
not.
offer to do that? My review of the record is that they offered to vacate the discipline and walk away and pay even some of your attorney's fees. Does that not happen?
It was later determined, and I believe that it is in our brief, that it's on page 7 and 8 in our conclusion, where we talk about the Reddings offer to settle either by SEVRAR vacating the discipline and no attorney's fees paid by the Reddings, or mediation. SEVRAR now says that SEVRAR never had any authority to vacate the discipline, and that's the whole reason why we're here.
Okay. So just so I'm clear, though, if he gets up and says, yes, we'll give you your appeals hearing with a 5-member board according to our rules, you'd be okay with that, and we could stay our appeal and let you guys go exhaust that remedy?
As long as part of exhausting that remedy includes the vacation of the discipline,
Well,
then
if
yes.
you won the appeal, the discipline would be vacated.
Yes, as long as we had that assurance, yes.
Okay. Thank you very much.
Okay. I do have a minute and 24. Is
You
that
can
in
use whatever
addition
you
to my
want.
8? Or, well, I just,
You might want to save it for rebuttal, because he may say something crazy that you want to respond to.
okay. Well, I tried to save 8 minutes. I guess I'm down to 1 now, so I will stop talking. Thank you.
Thank you.
Good morning. I'm Richard Mack. I represent the Southeast Valley Regional Association of Realtors, which is a mouthful, so I'm going to say SEVRA for short. I hope that's okay with Your Honor. I'm going to dive into the administrative remedies and exhaustion first, just because that seems to be hot and heavy with where you want to ask questions. The appeal has been offered since July of 2019. The Reddings have not.
Why didn't you just schedule it? I find their point pretty compelling. Your rules seem to say you're supposed to schedule the hearing, you provided them the notice. I get that there's a litigation overlay here that makes it a little different, but why not?
Understood. The appeal is something that, just like they did here, they need to prosecute the appeal. They didn't take any action, they didn't do anything to do it.
Do they set the appeal?
And in fact, when Mrs. Redding was asked in her deposition, have you ever requested an appeal? She said, no. Do you want to have an appeal? Under oath, she says, no.
So her deposition's testimony notwithstanding, an appeal occurred. They clearly asked for an appeal originally.
Yes. And the question was, do you want another hearing? And their position was, no, we're so fed up with you people, we don't want the hearing. Judge Gates gave them another opportunity.
Did Mr. Redding say the same thing?
Mr. Redding didn't. I unfortunately didn't ask him that question. I just got it out of Mrs. Redding. Judge Gates gave them another opportunity at the oral argument in August of 21 and said the same thing. If you want to move forward with this appeal, and if you look at the transcript itself, the burden is on them. If you want to go forward with the appeal with 5 members, not 4, tell me before August 26th or 7th.
Why is the burden? Cite me some case law saying the burden's on them, or in your contractual documents. Why is the burden? They asked for an appeal, just like they did an appeal to our court. Let's assume that our court issued a decision by 1 member, and it wasn't authorized under our rules.
Yeah.
It's defective. Do they have to go file a new notice of appeal?
They need to identify that they're going to move forward. There's certain forms or certain actions they need to take to prosecute that appeal, and they didn't do any of it.
Why is it that their burden, as opposed to you just set a new appeal? If you set a new date.
If you look at the rules and in fact the form they received, the burden to do that at this time was with their
I thought that was just to strike names. I thought that was to strike.
The form that they received said at the bottom, and if you don't, the date will be set, didn't it?
I don't think it says that, Your Honor, but I confess I'm cold on that very precise issue.
Let us know if you have any objection. But I think even if it doesn't say a date will be set, the implication is if you don't have any objection, there's nothing to say. It's not like, there's not like a box to check that's saying no objection and you're supposed to send it back.
The position is, and always has been, the failure to exhaust administrative remedies is an alternative sort of reason to justify the relief. Everything else still stands on its own.
Okay. Let me get to the point we were using up all of your opponent's time with. That appeal option is still there, correct?
Yes, sir.
Okay.
It has been since July of 19.
Okay.
Yes.
So why shouldn't we stay our proceedings today and tell you guys to go conduct an appeal in accordance with SEVRA rules and then let us know what happens?
Because the administrative remedy exhaustion concept is one of many ways that you can get to the resolution of the case. This case has been litigated extensely.
Right, but I'm saying even, let's say the trial court, let's say we affirm the trial court. It seems to me they still have their appeal right. You have vacated the appeal decision, correct?
Yeah.
They filed a timely request, you had a hearing, but that's been vacated.
Yes.
There is still an appeal that's pending.
Yes.
So why don't we wait to see what happens with that appeal? Because that's the whole point of exhaustion of administrative remedies, is we're supposed to let these extrajudicial processes resolve themselves. And they've indicated a willingness to do that. Are you not willing to let them go have their appeal?
We have been ready, willing, and able to have that appeal with 5 members since 3 years ago.
So we could issue an order today. I'm sorry. Go ahead.
I would hate
What
to
about the point that, can you please speak to the point, is the remedy that they seek in a successful appeal available or not?
Let me talk on that, because there's a difference between settlement and a court order. Early on, and I'm going to stay within the record. Early on, we did offer, we'll vacate everything and pay you $7,500 in your fees before we even filed an answer. We made that proposal. As the matter progressed, this is the part that's not in the record, but I'm going to say it anyway, and you can disregard it if you want. The National Association of Realtors got involved because they were seeking guidance as to what to do and talking about a potential settlement, and a settlement could not have occurred where the order was vacated. So the original offer was there. Had they accepted it, would have been fine. As we move forward, the national folks said, no, you cannot do that. So as part of the settlement, we cannot vacate the ruling. Court order, clearly we have to. But as it sits right now, we cannot vacate the hearing panel decision without an order from a court saying, you're wrong, you messed it up, you got to vacate it.
Okay, but there is a middle ground. So without the court order and without a settlement, if, as much as you would hate it, this court stayed and said, you have told us, I think 5 times now, just here today, that this appeal is still available to them.
Agreed.
And if we said, okay, go do it, we're stayed. So there's no court order to vacate the declaration that they were in violation of the ethics rules, and there's no settlement. Could that appeals process result in that remedy?
The appeals process could result in that remedy if there was a finding of a due process violation by the several appeal panel, yes.
Or the burden, the evidence had not been sufficient on grounds, any of the things that would normally have.
Whatever's available in that code could be the basis to.
They would have the full and unfettered right to any remedy that would otherwise be available according to several rules in the appeal process.
In that code book, yes, sir. That's right. That's right. But again, our position is that's an alternative remedy. If you look at what happened, there's a couple things.
So I just want to be clear, because maybe I'm just unduly optimistic, but I'm hearing that you do not object to a stay to allow the appeal to be processed.
I don't know that I'd go that far. I would urge the court to affirm on other grounds. I think the exhaustion of administrative remedies is only one of the ways that the court's decision can be affirmed.
What would that do? Let's say we affirmed on exhaustion of administrative remedies. You've already told us that their appeal right still exists, so the case is now done, and they file their appeal, and then they lose, or they win, but let's say they lose, because if they win, we're obviously done. But let's say they lose, they would then be able to go back, now having exhausted administrative remedies, and file their complaint, refile their complaint, and we'd be back to square one. So why would you want that as a remedy?
I think what he was saying is affirm on other grounds.
Yeah, you can affirm on other grounds, and that's my point, is exhaustion, now I'm regretting even putting in the pleadings. Exhaustion of the administrative remedies is one basis.
I don't see how we could affirm on any other grounds.
You're saying, just so I understand, you're saying Judge Gates, was it Judge Gates? I'm sorry, yeah. That she resolved every other issue in the complaint.
She made factual findings. Yes, sir.
Where do we find that? I mean, she said she granted your cross motion for summary judgment.
Correct.
Okay. I'm going to read to you.
I'll run through it.
I'm going to read to you from bottom of page 4 of her order. She is all in with you. She says, you guys didn't violate due process. They proved the things. But then she says in the next sentence, this is bottom page 4, top page 5, plaintiff's failure to exhaust the administrative remedy causes the court to grant defendant's cross motion for summary judgment. I don't know how else I read that other than saying the only basis upon which summary judgment is granted is the failure to exhaust administrative remedies. So I do not think I can affirm her decision on the, I'll call them the merits portion of the complaint as opposed to the exhaustion complaint. How else should I read that?
My take, Your Honor, is that she makes specific findings as to all of the other allegations that these folks made.
But she doesn't grant,
process.
She doesn't say, and for that reason I grant the cross motion for summary judgment. She says plaintiff's failure to exhaust the administrative remedy causes me to grant the cross motion for summary judgment.
If you read the minute entry, I understand. If you read the minute entry in its total, she makes findings and decisions based on all of the claims they've made. Due process, evidentiary issues, sufficiency of the evidence, all of the things. And there's one reason
that she grants the cross motion.
Well, there's one reason among many others. She exhausted it based on the failure. She granted the motion based on the failure to exhaust administrative remedies. But that's not the only reason. If you look at that minute entry, she made extensive findings of fact, all of them, all the critical findings of fact, based on the undisputed testimony of the Redding's own expert witness. So if, to answer your question, and it's proving a negative to some degree, if that was the only basis for her ruling, this could have been a half a page minute entry. I find that the Reddings have been given an opportunity, have not exhausted their administrative remedies, therefore motion for summary judgment in favor of Sevrar is granted. It doesn't say that. There's 5 pages of single-space, very specific findings addressing all of the reasons why the Reddings' allegations are not supported by the facts, are admitted by themselves and by their own expert, and are not supported by the law. So that's the roundabout answer, is because if that were the only reason, it would have been a half a page minute entry, and it's not. It's very extensive. And if I may,
In your opinion, there's no factual disputes? So there's no material dispute of facts?
no, sir.
In-
Based on, and if, please read our brief, but in the Mr. McDowell's deposition transcript, which we cited, all of the critical fact inquiries, due process, the right to cross-examine, whether the Fernandez complaint could be admitted at the hearing, the sufficiency of the evidence, every single one of those, their own expert admitted that the hearing panel got it right. So under the clearly erroneous standard, she had evidence that to a large degree, well, on those critical issues was not disputed, and therefore, I assert there is no material fact question.
But you're asking us to affirm, as a matter of law, discipline imposed to phase 1 of a disciplinary process where phase 2 has never been completed. Isn't that's in a nutshell? That's
Understood. In a nutshell, yes.
Is there any authority for that? Have you found?
No.
This isn't. This is such an odd.
It's a nitsy little case, I understand. I'm not aware of any authority for that. I apologize. I don't know that that exists.
Because it's been vacated. The appeals decision was vacated.
Yes, sir. Yes, sir. But it's been vacated, but they've admitted on the record in deposition that they
One of the
don't
2 parties did.
want an appeal. Judge Gates gave them the opportunity for the appeal again in August of 21. They did not pursue it.
But we heard today they're willing now, so why wouldn't we just stay? I'm trying to get you to just tell me to stay this.
I don't want you to say it because we've come too far. I mean, if I must be honest. I understand the position. I understand. I believe there are, and if you look, I guess, let me tackle it this way.
You're not conceding that we should, but you're agreeing, and don't let me lead you.
You sound like a lawyer.
Yeah. You're agreeing that that is an option available to the court, and there'd be nothing improper about us doing that.
Other than that, yes, I agree.
Thank you.
Other than that there are other alternatives available, that's the position.
I have a hard time reading her order, and I get there's a lot of extraneous there, but the only thing that she actually granted summary judgment on was the exhaustion of administrative remedies, at least as I read the order. I realize you are asking me to read it holistically, but I don't see how we can affirm on any other basis.
She made, I'm going to say the same thing over and over. Understood.
Thank you. No concession. I'm not.
No concession. May I talk about the other things, or are we just going to let it go? I understand where you're headed, but no, I've already talked about it. If you look, again, the public trust doctrine, there were factual findings on, we acted consistently with the code. The notice provision is attached, the notice of the complaint, the ethics complaint was attached to the plaintiff's complaint in the trial court below, specifically identifies Articles 1, 3, and 15, which was what was heard. The Fernandez testimony, the Fernandez complaint, their own expert admits away, says, yes, that's fine, you always look at the complaint. And as to Fernandez testimony, the Reddings have the ability, if they so choose, to bring parties in, Ashley Fernandez to testify. Their expert also admitted that. Again, there are extensive factual findings that address the rulings made. The factual findings are supported by the evidence provided by the Reddings' own expert. And the judge in her minute entry talks about, this is the September 9 minute entry, substantial evidence was considered to support the hearing panel's decision. In fact, the Reddings' own expert acknowledged the hearing panel received sufficient evidence to conclude the Reddings failed to protect their client's interest by not adequately educating their client as to consequences of simultaneous closings and failing to protect their client's interest, etc. So the sufficiency of evidence has been addressed. And, Your Honor, I guess the other point, if you're inclined to send this back or stay this so a 5-member appeal panel can be convened to hear the appeal, please, please, please look at the basis for the appeal by that Board of Directors hearing panel. It's very similar, and I'll say virtually identical, to the review provided after an arbitration decision. Has to be fundamental unfairness, fraud in the system, or due process violations. So I will venture to say, if that's where you're inclined to go, if you look at what that new appeal panel would do, they would do the same thing that you do sitting right here when you look at somebody not liking a decision from an arbitration. It's a procedural review only. They don't delve into the merits. They look at the procedure. And if you want a supplemental brief as to where it is, I'm happy to provide it. I will confess I'm not ready for that right now. But it's a procedural review only. So what those 5 realtors would do would be virtually identical to what you're asked to do here, and you folks are quite honestly a lot smarter than they are. But that's what the process would look like. It's a limited scope review. It's not a rehearing of the merits. I hate to sit down, but I think I'm going to have to. Thank you.
Thank you.
Your Honors, if I may, I just wanted to have a brief rebuttal. First of all, with respect to the expert witness, the opposing counsel is referring to the cross-examination of the expert witness, not his direct examination where he talked about various criteria that had to be met for the due process. But I do want to point out that the ethics hearing panel had the availability of the seller herself, who said, and I quote, it's on page 30 of our opening brief, "Yes, I didn't move out. It was me, right? It's not the Reddings. The Reddings instructed me, you got to move out, right? They told me I had to move out." Then she goes on to say, "Now granted, and contractually, should I have moved out? Yes, I understand that I should, right? The escrow is recorded, mine was recorded. At that point, yes, the funds are transferred, it's recorded, I should be out." And then she says the words, "I understand that." That's not the Reddings' fault. I don't know what more the Reddings could have done. There you have it. The seller knew. She admits herself in front of everyone at the ethics hearing panel that she knew everything she was doing. In fact, we already mentioned before she had called the Chandler police 4 days before close of escrow.
I'm sorry, your time has run.
Oh, thank
Thank you
Your
very
Honor.
much for your arguments, both. We will take the matter under advisement. We'll issue our decision in due course. We are going to stand in recess to reset for the next argument.